Good afternoon. Attorney Protective would like to welcome you to today's webinar, Danger Zones, Preventing Legal Malpractice in Everyday Practice. Note that we have changed our webinar format and now track attendance through your email with no need to use a personal. Before we start the presentation, the team at Attorney Protective would like to express that we understand that these are unprecedented times. Due to COVID-19, we expected that many webinar attendees would be logging in remotely from home or a location other than their office. Therefore, to prepare, we took extra steps to try to ensure that the webinar runs smoothly. However, if for any reason an unforeseen technical issue should occur, be patient as we try to provide the necessary support. If you experience voice or audio issues, please refresh your screen as this is most likely a connectivity issue that can be easily resolved. Please note, in order to be in compliance with state requirements for CLE, we will be asking polling questions throughout the webinar. Please look for those questions on your screen during the presentation and answer them as quickly as possible. Each question will remain on your screen for 1 minute. Certificates of attendance will be emailed to participants within 1 week of today's webinar. In order to comply with CLE requirements, we will not be giving formal introductions today. Please reference your materials for information about today's speakers, attorneys Seth Laver and Matt Marrone. With that, I would like to introduce your first speaker, Seth.
Thanks, Erin, and thank you, Attorney Pro, for inviting Matt and I to present today. We always look forward to this presentation. We're going to be spending an hour together, and there's a lot of ground to cover, but we're focusing on traps facing attorneys. The reality is that it's quite impossible to instruct everyone on the line about how to prevent malpractice claims. It looks like there's about 1,500 of you currently and more on the way. So that's a lot of different practice areas, hundreds of different variables and jurisdictions. There's personalities involved. So there's just too much to prevent all claims. But we found that there's some common themes that may resonate with you. So that's the goal that we want to hit on. We're going to spend a minute giving you an overview of what we hope to cover today. First, we're going to throw some numbers at you, statistics, to prove that claims against attorneys are on the rise, and unfortunately, perhaps even more so due to COVID-19. We'll cover who are the typical plaintiffs and what the likely liability theories are. We'll discuss the beginning and end of an attorney-client relationship and some traps along the way. Of course, we'll be covering conflicts. We're going to talk about the problem client, and then we'll conclude with some takeaways. And of course, we want to allow time for the Q&A session because we've seen in the past that you will have some excellent questions. Okay, we're gonna start with the bad news. According to insurers and consultants who compile this data, legal malpractice claims continue to be on the rise. More suits has been the trend for the past decade or so. And it gets worse, and we'll get into this later, but the exposure and the cost of defending those suits is higher, more expensive than it ever has been. And then finally, it's fair to expect an uptick in claims, we think, due to COVID. So this is all bad news. But the data on your screen and in the slides that follow is helpful because it helps us to address why these numbers are rising. If we can understand why, it helps us to reduce those risks in your practice. So I don't plan to address every bullet point on your list, but I'm going to hit some highlights. First is the first bullet point. There's more lawyers today than ever in history. I looked this up yesterday, and there's about 1.5 attorneys in 2020. On average, about 200,000 more attorneys every year since 2008. Although those numbers are starting to trail off a bit. Attorneys are living longer and retiring later. So what does that mean? It means that there's just more attorneys to sue. It also means that there's more competition. And competition in a lot of fields can be a positive, but there's also some downsides. Competition may provide us with more reason to overpromise or overextend to keep or secure a client, more reason to set unrealistic expectations, also perhaps more reason to dabble outside of your comfort zone. What's dabbling? Dabbling is when we take on work that we don't normally perform and that unfortunately can often lead to a lawsuit. The second bullet on your list, and again, I promise I'm not going to go through all of these, is insurance. Our carriers know these numbers better than anyone. They know that the claims and expenses are rising. Brokers know these numbers too. So what does that mean? It means that many of us carry more insurance. Insurance, of course, is an important risk management tool. It's a must, but it also means a larger pocket for would-be plaintiffs. And the downside there is that would-be plaintiffs may be more willing to target these large malpractice policies. Let's go on to the next slide where we're going to dig into the numbers just a little bit more. Keeping up with the statistics, let's consider what types of attorneys are most likely to be sued. The first one there is trust in estates. They're statistically the most likely candidate for a legal malpractice claim. And that's been the case every year since 2013 or so, according to what we've found. The most vulnerable of all attorneys is the solo practitioner trust and estates attorney. And Matt and I believe we know why that's the case. Trust and estates attorneys handle personal, sensitive matters. There's a level of trust there and vulnerability, often some hand-holding, and it may ultimately lead to a feeling of dissatisfaction or being let down. It becomes somewhat emotional. Also, trust and estates attorneys the claims themselves involve all sorts of conflict issues, and conflicts spark lawsuits, which we'll get into later. And finally, due to the role beneficiaries play in trust and estates matter, the pool of plaintiffs, the potential pool of plaintiffs who could sue a trust and attorney is higher than that for other attorneys. So we could spend time on really each bullet point on this list, but I do want to focus on collection just briefly. Now, I'm not aware of any specific stats on this, but in my practice, and I think Matt would say the same, we found that just about any time one of our clients seeks to collect unpaid fees by way of a lawsuit, they get sued themselves. So collection claims are really risky. They're important, but they're really, really risky in that they can result in a counterclaim. Matt?
Thanks, Seth. Good afternoon, everyone. There's a few things that jump out at me from these last few slides. I've been defending lawyers for the better part of 20 years now, and certainly we've seen an increase in claims over that time period. If we go back to where we were maybe 20 years ago or before that, there just weren't as many legal malpractice claims. There just weren't. There weren't as many legal malpractice plaintiffs. Lawyers were generally less willing to sue other lawyers. It was just kind of almost like an unwritten code. And for anybody who's been on this presentation in the past, you've probably heard me say this before, but it's true. And certainly what we've seen over the last 20 years is people are basically starting to use legal malpractice cases as almost like a risk transfer device. Where whenever there's been, whenever something has happened where a lawyer's been involved and a client has gotten a result or a plaintiff has gotten a result that they're not satisfied with, they're just more willing to sue the lawyer, any lawyer who's involved. Just whether they're representing that client or not, the lawyer gets dragged in. And Seth, to pick up on this slide that's up right now, the practice areas of generating the highest number of claims, I agree that the studies prove and our practice proves that trusted estate lawyers are in the crosshairs right now. They're facing all kinds of claims from all different sources, and they're complex and they're messy and they're expensive. But beyond that, again, sort of as a trend over the last 20 years, I would say, and sticking with the risk transfer, we can talk about lawyers who practice in two broad areas: litigation and transactional. And transactional lawyers now are are the ones who far and away are facing exposure and liability for legal malpractice more than litigation attorneys. I mean, litigation attorneys, if you miss a deadline, blow a statute, we still have those claims for sure. Whether the client agrees to a settlement that no longer later on they become dissatisfied with and they sue their lawyer, we see those. But lawyers who are handling real estate transactions, commercial transactions, trusted estate work, those are the lawyers that are getting sued much more frequently because, again, something goes wrong with the deal. Something later on, happens where the client says, well, this isn't what I expected, this isn't what I want, and the lawyer ends up getting sued. So that's absolutely what we're seeing, and those are sort of my general comments over the last few slides.
Great. Okay, let's move on to the next slide, please, where we're going to talk about, again, some numbers, but this is the most frequent allegations against attorneys according to recent publications. Conflicts of interest, of course, is at the top. Conflicts are reportedly the highest by a magnitude of like 2 to 3 times all other risks. And those risks are growing as firms expand through mergers. Reportedly, firms just don't have competent conflict safeguards in place, so conflicts remain a problem. We want to move on, but take a look at the remaining items on the list. Some of these are preventable, and others can be just bad luck. Still, knowing these risks may help to avoid them in your practice. Okay, then the next slide is our last, covering numbers. And we alluded to this earlier. Not only are lawsuits on the rise, but the costs of defending those claims are higher than ever, and the exposure is the highest in history. There are more claims with reserves of $500,000 or more today than ever before. The claims are larger, so the costs of defending those claims are higher, and the attorney's fee to defend those claims are rising. So what does that all boil down to? We know that claims are rising. We know that the cost of defending those claims are rising, and we know that exposure is rising. And in the midst of all this, we reach March of 2020, give or take, and COVID-19. If you look at the next slide, please. After the 2008 recession, there was a dramatic surge in legal malpractice claims. Businesses failed, and clients sought other means to recover. Clients were perhaps, and Matt mentioned this earlier, they were more willing to file suit than perhaps they would have in a better environment. Now, we just don't know, but there are experts who predict that COVID will spark a similar spike in malpractice claims. There's just so much risk in 2020, perhaps more so than ever before, so we just have to think about what to do about it. And we've identified four bullet points. Let's start with awareness and planning. What does that mean? As a result of COVID-19, deadlines are changing. Statutes of limitations are in flux. Court rules are modified. All professionals, all attorneys need to be aware of the rules and be sure to follow them. Moreover, attorneys are employers. We need to make sure that our internal firm documentation and our handbooks are up to date. That's what we mean by awareness and planning. How about operating the law firm? Many of us, if not most of us, have shifted to some form of a remote environment, and therefore we rely on technology differently. The failure to adapt to technological advancements or changes can constitute negligence. So we just need to adjust to these new systems. The third bullet is client service. 2020 has been particularly hard for attorneys, but the client, we cannot allow the client to suffer as a result. So consider what I call the 4 C's: communication, confidentiality, civility, and control. I'll touch on each of those briefly. Communication. We must maintain consistent communication with clients during COVID. We need to keep the client in the loop. Confidentiality can be more difficult in a complete remote environment. Civility speaks to the benefit of adjusting your tone and your approach to litigation or to your practice during COVID. There are ethics committees. I know there was one, I think the LA Bar Association has urged attorneys to extend every professional courtesy during COVID. And then finally, what we mean by control is to monitor and supervise colleagues in a remote environment the same as you would in the office. Of course, we can't go door to door and check on each other and touch base, but we need to utilize whatever other means are available to us to monitor and control our colleagues. Finally, security, and that's our last COVID point. Let it be said, by the way, we could spend a day talking about the implications of COVID, but we will not do that. We're trying to keep this down to the most important points. Security is the last point on this list. Be mindful of the very real risk of cyber and physical crime during COVID. Fraudsters have taken advantage of COVID to gain access to confidential materials. If we're working remotely, who's safeguarding your physical office? You need to keep both of those risks in mind. Okay, so now let's turn to the potential plaintiff and who is suing attorneys, and Matt's going to take that next slide.
Thanks, Seth. One real quick point that I'll add just as a footnote to the COVID, and we don't need to go back to that slide, but we're friends and we're colleagues with people that do this work around the country through the different organizations that we belong to and just the networks that we have, and there's really there is speculation and sort of uncertainty about what legal malpractice claims are going to come from COVID. Seth is definitely right that in the wake of any financial or economic crisis, legal malpractice claims and other professional liability claims, again, as a risk transfer tool, tend to spike. And, it's certainly reasonable to think that's going to happen here, but we're not seeing them yet. We're not seeing them yet. We're not sure if we're going to see them, what they're going to look like, how many of them they're going to be, and I think it's actually my own personal opinion. It's going to depend on what states that we're in. For instance, some states only have a 1-year statute of limitations for legal malpractice claims. That statute might come and go before somebody even realizes or files a malpractice claim that kind of stems from COVID. New Jersey, which is an area where we practice heavily, has a 6-year statute with liberal tolling. So are we going to see them there? Certainly more likely, at some point down the pike to see them coming there. But at this point, we're not seeing them, and we're not really sure what's going to happen. But Seth's risk management tips there for everybody on the line are excellent. So legal malpractice exposure, I sort of touched on it earlier. I mean, traditionally the attorneys were exposed to a claim only from their client. The client hires the attorney, and the attorney represents the client. And if something goes wrong, the client, sues the lawyer, and that's pretty straightforward. That's the way that it went. Now, not at all. I mean, we are seeing increasing theories of liability, and courts, at least where we practice, courts increasingly willing to allow non-parties, let's say, non-clients outside the scope of the attorney-client relationship to sue lawyers. For instance, let's say you're representing one side of a deal in a transaction, one party to a transaction, and the other party chooses not to be represented, even though you tell them you should have representation. They say, no, forget it. You're drafting the documents. We're good with that. We don't need to hire our own lawyer. Well, guess what? If something goes wrong and that deal goes bad, and the person who's unrepresented feels like something went wrong, they're now suing you, saying, well, you were the lawyer for the deal. Is a phrase that we've heard before. You were the lawyer for the deal, so you had a duty to us as well, which personally we believe is wrong, but there are certainly some judges and some courts that are willing to at least entertain that, based on how those claims are couched and how they're pled and everything else. So That's one example, but one that we see many times in legal malpractice claims, that you just have these other people, these non-parties that are outside the scope of your relationship that are now suing you, claiming that you owed some duty to them. I think we're going to the next slide now. Okay, so yeah, so I mean these are the traditional liability theories. I don't think that there's any earth-shattering news here. I mean, typically, historically, traditionally, I mean, a legal malpractice claim can take the form of either a tort, negligence, or contract. Certainly, states will often allow them to be couched under either one of those things. Some states have streamlined it and said that no, any malpractice claim is just a negligence claim. In some states, you actually have disparities between statutes of limitations in negligence or contract. For instance, in Pennsylvania, we have a 2-year negligence statute and a 4-year breach of contract statute. So a lot of times, if a client wants to sue and they're beyond 2 years, they'll phrase it as a breach of contract claim, and we need the courts to give us some clarity on that. Misrepresentation, breach of fiduciary duty. Those are often, of course, you'll see those if you're faced with a lawsuit from your own client, but those are claims that you'll often see coming from non-clients as well. That I understand you didn't represent me, but you misrepresented something to me as part of this deal that I relied on, and you as the lawyer should have known you were misrepresenting something, and therefore I'm suing you. Same thing, breach of fiduciary duty. In some states, the courts will allow a non-client to, under certain circumstances, to assert a breach of fiduciary duty claim against the lawyer. We'll see this. For instance, we'll see this if a lawyer is administering an estate. They're not representing the beneficiaries, but certainly they have a fiduciary duty to administer the estate properly. And you can face claims from the beneficiaries of that estate by way of the administration, claiming that you breached your fiduciary duty to administer the estate. You created waste and mismanagement. You didn't pay off the taxes, things like that. Didn't sell this house fast enough for enough money. And even outside of the estate context, we see claims from non-clients for breach of fiduciary duty. Fraud, that's another one, basically misrepresentation, just intentional misrepresentation. And then conspiracy, we're still seeing that too. I mean, it always never ceases to amaze me how clever and creative and frankly overreaching plaintiffs' lawyers will get when suing lawyers. Where a simple malpractice or breach of fiduciary duty claim might suffice, no, they're going to throw in, conspiracy, that the lawyer conspired with his own client and everybody else to, defraud this person. And, I always look at it and just think, why do you need this? Just go with the straightforward claims. But, so we're still seeing those. But, the conspiracy is not all that common, I would say. But we do see it, and sometimes, it's pled with the purpose of trying to get punitive damages, for instance. So I think that's it for that slide. We on to the next one. Is this still me?
That's me.
Okay.
Thanks, Matt. So in terms of how we evaluate attorney conduct, we look to several standards that are listed here. We start with the standard of care in each jurisdiction. And usually, and I can't speak for all jurisdictions, but usually it's what would a reasonable attorney in the area have done in this scenario? That's the first place to look. We also have guidance from the rules of professional conduct, which may be different in each jurisdiction. And there's also the model rules. Now, remember, the rules of professional conduct are merely a guide. Breach of those rules does not automatically mean a breach of the standard of care, but it's likely evidence of negligent conduct. Next, we'll look to cases applying the law to attorneys. Then, if we need additional help, we'll turn to the cases applying the law to other professionals. And then finally, we look to state regulations to evaluate attorney conduct. In terms of hierarchy, the standards hold the most water, followed by case law, and finally, state regulations. Now we'll turn to Matt, who will talk a bit about the attorney-client relationship.
Excuse me. Yeah, I mean, there's a couple of ways. Well, the obvious way that an attorney-client relationship is formed is when client comes into your office. You talk to that client about what he or she wants. You discuss your rate. You discuss what you're going to do, and you reduce it all to a retainer agreement, a letter of representation, whatever you want to call it, and it's signed off, and you're good to go. And then when the engagement is over, when you've done everything that you're going to do, the ideal thing to do is to send a letter confirming that the representation is over, and everybody goes their separate ways. Unfortunately, certainly in the malpractice lawsuits that we see, those instances are the exception rather than the norm, and there are other ways that without a retainer agreement that the attorney-client relationship can be established. And basically, if the client says, that I came to you to talk about this, you can send it to represent me, and you never told me you weren't going to represent me, and then you don't do something, that can put you on the hook for malpractice claim, because arguably an attorney-client relationship was established. So when the client is sitting across from your desk and you're talking about what it is you're going to do, but you don't say I'm not going to do this, or you never really confirm it afterward, it can increase the exposure for you going forward. Same thing if you don't specifically end it when it's over, that can be problematic, because the client might think that you are still going to do something more. So next slide here.
Yep. So what Matt just went through may seem straightforward enough, but defining the beginning and end of an attorney-client relationship can really be a problem. Matt walked through sort of the usual scenario with a client sitting at your desk and you sign into a retainer agreement. But there's many instances where an attorney can fall into traps because he or she just didn't confirm whether they did, or maybe even more importantly, did not agree to represent the prospective client. What sort of traps are we talking about? You can run into a problem with casual or informal advice, whether it's friends or family or friends on the soccer field. They may all ask for informal advice. It's usually harmless, but it's risky. What if the recipient of that advice relies to your detriment on what you said? They think incorrectly that you're their attorney. They don't have an actual attorney. They rely on whatever you said, and something goes wrong. It's a casual conversation that the client takes seriously, and something goes awry. What about a casual referral that goes terribly, or a off-the-cuff suggestion that results in a blown statute or another error? There's no engagement letter. There's no attorney fee, retainer fee. You're not being paid, but still there's danger there. So all of us must clearly define the relationship from the beginning, even in an informal setting. And sure, it may sound paranoid, but it's important. At the very least, do what you can to avoid confusion. Keep your spider sense up. Think before you speak. Just be careful. If there's no intention of representing an individual, let them know it and ensure it's understood. And like many things, if at all possible, follow up in writing. Let's talk about online advice, which many of us may do in one form or another. Many of us use legal blogs, social media for marketing purposes. This can be a problem. Every day, attorneys provide legal advice to anonymous clients in cyberspace, and that's a real trap. We should feel free to market ethically online, but include disclaimers, and chat rooms in particular are a real problem. I would consider avoiding those altogether. The last two bullet points, disengagement and declination letters. Let's talk about the importance of those. Sometimes it's unclear when a relationship begins, but it can also be unclear when a relationship ends between attorney and client. The disengagement letter is the perfect tool to clearly define the end of a relationship. The case could be over, the transaction could be over, or there could be a difference of opinion with the client. That's when a disengagement letter comes into play. What if the client stops cooperating? What if the client stops communicating or paying you? That may be time to disengage. Now, there's ethical considerations to keep in mind when disengaging. You often must ensure that the disengagement doesn't unfairly impact the client, and that will be governed by local rules. So consider adding disengagement letters to sort of your risk management toolkit, and if you don't have those, consider contacting counsel, following up with your carrier or broker who may have templates that you can work from. Finally, a declination or non-engagement letter. These two are a must. You need to ensure that the potential client knows that they're not an actual client. Make clear to them that you're not their attorney. Make clear that you're not accepting the engagement. Make clear that they cannot rely upon you. Even for existing clients, a declination can confirm the scope. It'll help you define what you will and will not perform, say, additional services for the client. Keep those bookends on what you are doing and what you're not doing. Next slide, please. We'll talk about the scope of the engagement. Everything that we do as professionals is defined by the contract. In accounting, bookkeepers are not auditors, architects are not engineers, dentists are not plastic surgeons. Clients engage us to perform defined tasks, and we're judged based upon what we were hired to do. So it's essential that we obtain clear engagement terms. It's also an important way to set and manage expectations, and along those lines, the more specific we are, the better. After a lawsuit, after it hits the fan, we look to the engagement letter to define the respective roles and expectations because that's the contract. So the scope of the engagement is critical. And then from there, we need to confirm that the defined scope of the engagement is consistent with the attorney's conduct, what we actually did. So take a look at your time records. Do the invoices match the client's expectations? Do the task descriptions that we billed for, do those conflict with the engagement letter? That would be a problem. Also, look at your website. What services did we identify on our website? What representations have we made publicly? What's been advertised? In the wake of a lawsuit, the plaintiff has checked your website and will use it against you if she can. So you need to think about these sorts of things now because we'll definitely be thinking about them once a lawsuit arises. That's how we define the scope of the engagement.
None of this stuff is an exact science that we're talking about, and it can be complicated, it can be difficult, and it can be very fuzzy. I think, from a practical standpoint, the point is to do the best you can to identify who you are representing and for what. And what you aren't doing, who you aren't representing. I can give some examples of some cases that we've handled that sort of, underscore this. For going back to what I said, where let's say you're representing one side of a business transaction, and maybe, your client hires you to draft the documents, and the other side of the transaction says, no problem. The document you've drafted the documents. I've decided I'm doing this deal. I'm just going to sign it. Let's stop there. In a situation like that, the best thing for you to do is to tell that other side, either in the document itself or in a letter. I'm not representing you. You are entitled to your own counsel. I am not your counsel for this. It's now look, I've handled lawsuits where even a lawyer under those very circumstances got dragged into a lawsuit, but that's a good practice to do. Where somebody, who you think later on might think that they're relying on you. Shut it down as early as you can to set them straight, make it clear that you're not their lawyer. Another situation, sort of the scope of the representation, and this is an example for anybody who's on the line that maybe has a long-standing corporate client, let's say, that where you serve as maybe like outside general counsel for them. That's tough to do. I mean, what are you going to do? Are you going to send when they call you for advice on something on a Tuesday and they need a quick answer? Are you going to send them an engagement letter for that? No, but I represented a lawyer one time under these circumstances. He was essentially outside general counsel for an engineering company. The engineering company got sued, and he said, well, look, I can also handle this piece of commercial litigation for you. And there was a discussion with the engineering company. Well, should we report it to the malpractice carrier and let the malpractice carrier handle this? And the lawyer said, well, why don't we just wait and see how this goes? Let me handle it, and if we get in deep enough, far enough, and it gets complicated enough, then we'll report it to the malpractice carrier. Well, the problem with that, and I'll address this a bit later on for you all as a risk management tool, malpractice policies are claims made and reported policies, meaning that there's only going to be coverage if you report the claim when it's made. You can't wait 2 years and then say, okay, well, now it's not going well, we're going to report the claim and let the carrier get involved. And that's exactly what they did. So the client then ended up getting hit with a judgment, and the client sues the lawyer, saying, you had an obligation, you had a duty to tell me early on to report this to the carrier. And the lawyer said, listen, no, that was your decision. That wasn't even my role. My role was to represent you in a litigation. What you decided to do with respect to your own insurance policy is your business. Of course, there was nothing in writing about any of that. And I would say that that's actually one of the things that we put in our engagement letters for the clients that we're handling in litigation, that we're representing you in this lawsuit. It's not our responsibility to advise you about your insurance coverage. It's not our responsibility to tell you to go seek out excess insurance or anything like that. That's on you, because you have to do that so that later on, you're not faced with a claim. Well, you are my lawyer. It relates to everything that you were doing. You should have counseled me on this better. So, I mean, again, it's not. It's obviously situation specific. There are tons and tons of examples that we can cite and go through, but it's just the slide that's up there right now. You want to be wary of these principles. I would say if you take nothing else away from this presentation, and I certainly hope that you do take a lot away from this presentation, this slide in front of you right now is what you is the best thing. The most important thing that you can do, having an engagement letter that outlines all of these things. And if it starts to change during the course of your engagement, if, for instance, you're drafting a will for a client and all of a sudden now the client's bringing, sons and daughters to the meeting and they're chiming in about, what it is they want mom or dad to do, you need to say, look, I'm not representing you. I'm representing your mom and dad here on your wills. You're not the clients. Again, you don't want to be a jerk about it. You don't want to come off as rude to the family, but it is important, to make that clear that what you're doing, so that later on, the sons and daughters can say, well, we told you we wanted you to do this and you didn't do it. And these things happen. They definitely happen. So, keep all of this in mind for sure.
So the next slide provides some engagement letter clauses that we've found useful. These can aid your defense and potentially avoid a lawsuit altogether, and these are not in order of importance. First, consider defining who owns the file, and this will will vary by jurisdiction and may depend on the circumstances, specifically if you're owed unpaid fees. Ownership of the file isn't often an issue, but when it is, it can be a big mess. Usually only becomes a problem if something goes very wrong. So get ahead of it and consider including a ownership of work paper clause within your engagement letter. Along those lines, define how the client should address fee disputes, how and when the client should raise any issue or question, and how any resulting issues will be resolved. This should be defined in the contract. Consider a mediation clause. Again, this may vary by jurisdiction, but many of us know the benefits of mediation. And courts have grappled with whether mandatory arbitration or mediation clauses are enforceable in attorney-client contracts. But I'm sorry, I misspoke. The arbitration clauses courts have grappled with, but mediation clauses often are enforceable. Stop work clauses are particularly useful when a client refuses to pay your bill. Consider adding a clause that makes clear that the attorney will stop work unless or until they're paid in full. And that is an important and clear way to protect yourself, because none of us want to work for free. All right, let's talk about conflicts.
Yeah, before we talk about conflicts a little bit here, I want to touch on a point that Seth just made. We've gotten this question in the past, and I get this question a lot of times about arbitration agreements in your retainer agreement. That says basically like if there's a dispute between client and lawyer, client agrees to arbitrate the dispute in such and such forum in such and such place, something like that. The idea being that, you as the lawyer feel like you are limiting your liability or basically limiting your liability for a malpractice case. And I will say that personally, I don't like them, and I tell any lawyer that wants to use them that I don't think that they should use them, because there are several courts that have ruled, and this is the trend, that by putting that in there, you are infringing. You're basically taking away a right of the client. You're taking away the right of the client to go to have their dispute heard in a court of law and have a jury trial, and that if you're going to do that, you need to then tell the client that they have to seek independent counsel before they sign that agreement. Now, some jurisdictions permit them. Some lawyers like to use them. They can be useful. I have seen them where they have been beneficial, but I generally don't like them. If you are going to use them, I suggest that you limit it only to a dispute over your fees. That's something that, in general, again, this is all state specific, but that's something that I think that you can do. You can't require them to litigate a malpractice case in a binding arbitration forum. I just don't think that you can do that. But if it's a dispute over your fees, I think you probably can. So be careful about that. If you're going to use that sort of a clause, do some research in your own state, case law, rules of ethics, ethics opinions, those sorts of things, to make sure. So conflicts of interest. I mean, the rules are up there. What I'll say is, going back to the increase in litigation against transactional lawyers, conflicts of interest are a huge driver of claims. It's the number one driver of claims that's been cited in every survey that I'm aware of. And they can take many forms, kind of going back to the unrepresented party to a transaction. Well, they're a non-client, but they're alleging that they were a client, that you owed them a duty, and that because you didn't counsel them correctly, you had a conflict of interest by representing both sides of the deal. That's one example. And there are many others. Certainly in the estate planning, the estate administration process, there are, where the estate administration, for sure, if you're going to pay money out to certain beneficiaries and not others, in priority, or representing the estate, doing the planning and then the administration under certain situations. Again, it's we could spend an entire day talking just about conflicts of interest, but don't just sort of some general basic rules that I hope you're already all aware of. Have a conflict check system in place in your own firm, where before taking on a new matter, if you have represented somebody else in another matter, or in a substantially related matter, don't represent multiple sides of a deal. Those are sort of the if I can give you bullet point helpful things, those are the easiest ones. But again, just be wary of the people, the different parties that are involved in whatever it is that you're doing, and who you're representing and who you're not, and make it clear so that somebody later on can't say, listen, you had a conflict here. You were wearing different hats, and because what they'll do is, even if they weren't harmed precisely by that conflict, it becomes almost like a theme of the malpractice case. I mean, there's certainly in high-profile malpractice cases that make headlines in Law 360 or other sources against big firms. If you're in a big firm, that it's something that you're more at risk of. I think those are you see them. They have jury appeal. That these greedy lawyers sold one client down the river to the benefit of another. They didn't want to turn down representation, so they took this on, and they had a conflict, and they can result in big verdicts. We've seen them. So those are sort of the if you think there is a conflict of interest or a potential conflict of interest, it's best to get it out there, let the client know. Conflicts of a lot of lawyers, I think, are I'm sort of contradicting myself here, but a lot of lawyers, though, are also overly cautious on conflicts of interest. I mean, it's if you look at the rule, you take a strict reading of it. Just be familiar with the rule, and and if there is a conflict, or even if there's not, just let the client who you're going to be representing know. Just be upfront with them about it. That as to why, as here's the situation. I don't view this as a conflict of interest, and we're good to go. I like that approach much better than using a conflict waiver letter. A lot of lawyers, if there's a potential conflict, or even one that could be construed as a potential conflict, they have the client sign off on a waiver of a conflict of interest. And, I was talking to a plaintiff's lawyer once. I did a presentation maybe about a year and a half ago just on conflicts of interest. And she said, as a plaintiff's lawyer, that conflict waiver letter is my favorite piece of evidence, because what it shows is that there was a conflict of interest and that the lawyer proceeded anyway. Because, clients, at least, from her perspective, clients can't meaningfully waive conflicts of interest. They're going to look to you about what you think it is. So these are all, that's the best kind of summary that I can give you on conflicts of interest. And okay, so I guess we're on to the next slide here. Next slide, please. Okay. This is again, anybody who's come to this presentation in the past, I know will remember this slide, because it's one of my favorites. I mean, the best from a risk management perspective, meaning how to avoid getting sued. Let's put it that way. I mean, we can talk about how to avoid malpractice, how to avoid doing things that will lead to a claim. We've talked about the letters of engagement, the fine scope of representation, who you represent for what. But I mean, honestly, I mean, we all have our own intuition here about what clients are, might be difficult and just might be a problem down the line. And I like to say that if you can head something like that off, either at the beginning or while it's going on, you're going to limit the headaches and limit the potential for a claim down the road. And so I call it, the problem client. How do you identify them? Well, if they've already fired one lawyer or two lawyers before they come to you, your radar's got to be up that this person, just either they're not paying bills, or they can't be satisfied, they can't be pleased. That's the kind of person that later on, if you do sue them for fees or you don't do a good job, they're coming after you. Never satisfied, same thing. The client that thinks that they're a bigger deal than you are, that they're doing you a favor by giving you the business. I mean, look, we're all lawyers. We're all trying to make money. We're all doing this for a living, and we all need to take on clients so we can pay the bills. So, none of us wants to turn business away, but at the same time, you're offering, like Seth said earlier, you're offering a service for these clients. It's a two-way street. Unreasonable expectations kind of ties in with never satisfied, doesn't pay. We talked about that. Unresponsive. If you need information from the client in order to do your job, and you're asking them, they're not getting it to you. That's just not. That's going to be a problem for you later on. It's going to be a problem, especially if at the same time, they're demanding, or again, they're doing you a favor. They're too big for you. And we all have clients that are kind of like this, but it's a matter of sort of managing them and documenting things as you go, especially in situations where you do have a problem client. Documenting what you're doing and the things that they're not doing and how that's impacting you. Oh my gosh, I'm sorry, I'm looking at the question stream that just popped up. Somebody said this describes 90% of clients, LOL. Sorry. Asks for favors, always in a rush, those sorts of things. So, you just need to, if you do have problem clients, I guess those are the ones, if you want to keep them, if you want to keep working for them, if you're charging them a good rate, if they're paying their bills, just make sure that you're giving them sort of that extra attention and holding their hand so that later on they're not coming back to bite you. And again, sort of going like before, I mean, none of these things, there's no science to any of this. But that's, I can't tell you how many lawyers we've represented in malpractice cases where they were doing a favor for somebody. So many times I've heard it, doing a friend or a family member a favor. I wasn't even getting paid for it. They did it as a favor, and then they get sued. That's just it happens. So I think that's it for me.
Okay, some takeaways. What we do for a living is difficult. We work to build our careers, our reputation, our book of business. We work to develop a specialty. Let's not risk it all of that goodwill, that name recognition, only be sued for dabbling. To that end, we should practice what we know. Don't stretch and take on something that we're just not comfortable with. There's plenty of pressure to maintain client relationships, but we would think a client worth having will respect you more for sticking with your strengths rather than biting off more than you can chew. So practice what you know. Matt, do you want to highlight the avoiding the problem client?
No more than I just said. Avoid the problem client. That's all I have.
All right, and a reminder regarding conflicts as well. And then finally, with an effective engagement letter can really be your best friend. It can set the tone. It defines the contract and the scope. It is such an important tool to avoid the lawsuit altogether. But if you do get sued, a good engagement letter will be your defense attorney's first move. So with that, we're going to kick it back to Erin, who will talk about some of your questions.
Great. Thank you so much, Seth and Matt. Well, at this time, we would like to welcome you to ask questions. There is a dialog box marked Ask a Question on the left-hand side of your screen. Please click the box and then type your question in the dialog box. We generally receive a lot of good questions. Unfortunately, we won't be able to address all of them in the time frame that we have. Also, as a reminder, We will send CLE certificates by email within 1 week of today's webinar. And if the Q&A time extends past the 60-minute mark, it is not necessary to remain on the line for the full Q&A in order to receive credit. So Seth and Matt, we've been getting a lot of great comments just about the presentation, just saying that they really appreciate the practical and useful best practice tips that you've shared. One question that came in is, if a client is making a will or a trust, as the client's attorney, do I have a duty to the beneficiaries?
Thanks, Erin. I will answer that, but I just realized I missed something, and it's an important point that I want people to know before they leave. Another risk management point. Like we said earlier, if something ever comes up, if you have a situation with a problem client or a question, ethics question, whatever else, please, you should absolutely look at your insurance policy and contact your insurance carrier, because a lot of carriers, I know Attorney Protective for sure, they'll offer, something called pre-claim assistance, where they will get lawyers, like us or lawyers like us involved to help you. It's a benefit that you very well may have under your policy, and it's something that you should absolutely think about, because you're not in it alone. And secondly, going back to the example I shared earlier, if you are faced with, if something happens where something's gone wrong, you think that you're going to be faced with a potential claim, you've made a mistake, something like that, you should let your carrier know, because again, these are claims made and reported policies. And what that means too is that you have an obligation to report a potential claim, facts or circumstances that may lead to a claim. And if you don't do that on the policy period where that potential claim occurs, you might not have coverage later on. Now, I'm not saying that you have to let the carrier know every time you make some minor mistake, but same thing like with renewal applications. If you get a renewal application, a lot of times it'll ask you, are you aware of any facts or circumstances that may lead to a claim? Something like that. If you're in a firm, if you're in a small firm or even a big firm, you should circulate that to every lawyer in the firm, so that you're doing your due diligence to make sure that you've got that answer from every lawyer in the firm, because you don't want to be left without coverage later on if you do need it. I just want to make that point. So, okay, do you owe a duty to beneficiaries of an estate? I mean, so again, it's going to depend on state law. The states vary on the extent of duty that a lawyer owes to beneficiaries, but certainly if you're administering an estate, once the person dies and the will comes to you and you're administering the estate, definitely you owe duties to those beneficiaries to administer the estate properly, prudently. You've got a fiduciary duty to them. And we've got a case right now where the allegation is that the attorney who was appointed as administrator didn't do that, created waste, mismanaged things, incurred too much by the way of legal fees in administering the estate that left the beneficiaries without as much. So yes, depending on circumstances, you can owe duties to beneficiaries.
Okay, great. Another question that came in is getting a lien a good alternative to suing a client for fees?
I mean, I don't know how you get a lien without, a lien like on the file. I mean, attorneys' liens on files, again, I think are going to vary by state about what it means. I mean, sometimes, like if you're, sometimes they're automatic. I think, the law will say that you automatically have one, but. So I guess, I want to know more about the certain situation, but, going back to, suing for attorney's fees too, I wanted to touch on this as well, because Seth mentioned about collection earlier. I know a lot of insurance carriers, Erin, I know you guys don't like it when your insureds sue their clients to get paid for unpaid bills, for unpaid fees, because it absolutely can result in a counterclaim for malpractice. I don't like telling lawyers not to do that as an across the board rule. I mean, we're lawyers, we do the work, we do good work, we're entitled to be paid for that. And and sometimes clients don't pay, and if you have to sue them, especially if it's a big amount that you're owed, that's a decision that each person has to make individually. But what I will say for sure is that every lawyer needs to understand that if you do sue for unpaid fees, there's a good chance you're going to be hit with a counterclaim for malpractice, if for no other reason than leverage, bargaining power. You walk away from your fees, I'll walk away from my malpractice case. We see that a lot. So, in terms of pursuing clients for unpaid fees, I would just say that consider how much you're owed, consider what the client's like, consider, how likely it is that you might get a counterclaim for malpractice, and just, factor all of that into whether or not you actually want to go down that road. I mean, if you're owed a lot of money, I say go for it. That's just me, though. I know, Aaron, you might disagree.
I would like to remind everyone that we are past the 60-minute mark, so it's not necessary to remain on the line for the full Q&A in order to receive credit, although there are some more questions that I'm going to ask the presenters. So another question that came in is, how should I disengage from a client in a matter where my jurisdiction requires that I get the court's approval before I can officially withdraw?
Well, I mean, what you want to do, I think, in any situation where you're withdrawing from representation is you don't want to leave the client high and dry. You don't want to put them in a situation where they're being prejudiced by your withdrawal. Where they're facing some imminent deadline, where later on, because this can actually serve as a basis for a malpractice claim, that you abandon them, and put them in a situation where, they really, got stuck. I think if it is litigation, if it's a litigated matter, you're likely going to have to get the court's permission to withdraw. Unless they already have a new lawyer who's substituting in. And if you do get the court's permission, that should go a long way in protecting you, because the court, will give them time and give them the opportunity to find new counsel. In some sort of ongoing transactional matter or something that's stretching out over a period of, months or even years where it's not in litigation. Same thing, just write the client a letter, give them sort of a final status report about where things are, things they need to be wary of, and tell them you're out, that they should get a new lawyer. I mean, don't do it, just do it carefully, do it cautiously, do it in a way that the client can't later say, boy, you really stuck me.
Okay, great. Another question that came in is, are emails acceptable for disengagement or non-engagement letters if you always communicated with the client via email?
Good question. I would think absolutely, particularly this year where many of us are utilizing email more than the traditional printed letter. Absolutely. So long as your position is clear, and so long as you contain the language that you would have otherwise in a formal letter with wet ink, absolutely you can utilize email for engagement letters, for disengagement letters, and important correspondence of the like.
Okay, great. And one final question. Would suing a client for unpaid legal fees in small claims court diminish the risk for a counterclaim of malpractice?
Good thought. The risk of malpractice arising from a collection dispute is very high. The jurisdictional limits within a municipal court or lower level may modify things somewhat, but I still think that the risk is very real. The countersuit could potentially kick you into a higher jurisdictional limit. I don't know that it would do much to reduce that risk.
Okay, great. Well, at this point, we are out of time for further questions, and that concludes today's event. Certificates of attendance will be emailed to participants within 1 week of today's presentation. And on behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. And I would also like to thank our speakers, Seth and Matt. So thank you all very much, and have a great rest of the day.
Thanks, Erin.